surety. What is pertinent about sureties is that there must be an indication that they have been advised of their roles as sureties, they identified themselves properly and have shown and proved their authoritative relationships in respect to the applicant, showing that they are able to exercise their authority and command appearance of the applicant in court when needed. The accused person has substantial sureties within the jurisdiction of the court capable of ensuring the accused person's compliance with these bail conditions. Guideline 15 of the bail guideline sets out factors that court shall take into account in determining the suitability of a surety: age, work and residential address, character and antecedents, relationship to the accused person, and any other factors that court may deem fit. Documentation in respect of a surety that must accompany an application for bail includes a copy of the national ID and an introduction letter from the local council and chairman of the area where the surety is ordinarily resident. The applicant has sound and substantial sureties who have fixed places of abode within the jurisdiction of this honorable court. She added that all the sureties are aware of their duties to this honorable court, and in the event that she is granted bail, they undertake to ensure her compliance with all the terms set by this honorable court in this granted bail. The sureties the applicant presented were three. One, there was Honorable John Patrick Caballo, a resident of Chanamugera, Mugera Parish, Nalutuntu Sub-County, Kasanda District. He is a farmer and businessman and an uncle to the applicant. A copy of his national identity card and a letter of introduction from the LC1 chairman was attached to the application. Originals of the same were presented for court's inspection. The second was Mr. Geoffrey Kamuntu, a resident of Kasari, Balisanga, Okrite Sale, Namlanda Ward, Kajansi Town Council, Wachiso District. He is a businessman by profession and a cousin of the accused person. A copy of his national identity card and a letter of introduction from the LC1 chairman were attached to the application. Originals of the same were presented for court's inspection. The third surety was Major General Emmanuel Burundi Nyamunywamisa, a resident of Mbuyahi Village, Nakawa Division, Kampala, a retired officer of the Uganda People's Defense Forces, a diplomat and businessman. He is a cousin and next door neighbor of the applicant. A copy of his national identity card and a letter of introduction from the LC1 chairman was attached to the application. Originals of the same were presented for court's inspection. By providing copies of their national identity cards and letters of introduction from the LC1 chairman, where they ordinarily reside, the sureties satisfied the conditions set out in Guideline 15 of the bail guidelines. I am not persuaded by the respondent's argument that the first surety at the age of 76 on account of advanced age is not able to execute the duties of sureties which the respondent referred to as laborious. The first surety, by virtue of his relationship as an uncle of the applicant, wields authority over the applicant to ensure that she abides by the conditions of bail in the event that she is granted bail. After all, the duties of a surety do not require the surety to physically convey the applicant to court to satisfy her bail conditions. Had that been the case, the age of the first surety would then have been a disqualifying factor. Accordingly, the declared blood relationships between the sureties and the applicant augment their suitability as sureties. I therefore find that the applicant has satisfied the requirement to present substantial sureties. Now look at circumstances. The applicant sought to rely on Section 16(1)(a) of the TIA, which provides that court may refuse to grant bail if the applicant does not satisfy court that exceptional circumstances exist for her release on bail. Section 16(3)(a) provides that exceptional circumstances means grave illness certified by a medical officer of the prison where the applicant is detained as being incapable of being managed while the accused person is in custody. It was argued for the applicant that as a result of the domestic, she sustained injuries which have compromised her health, and that the Uganda Prison Service is ill-equipped to manage her health needs. In addition, the applicant was found to have multiple masses in her breast. In a report February 2024 by a team of medical personnel at Mulago National Referral Hospital, among other examinations, a mammogram, IRAD2 benign findings, the applicant was diagnosed with post-traumatic stress disorder, hypertension, for which she was found to be benign paroxysmal positional vertigo secondary to head injury, resolving soft tissue injury, breast fibrocystic disease. The recommended treatment plan was that the applicant receives trauma-focused cognitive behavioral therapy, continues with her antihypertensive treatment and blood pressure monitoring, follows up with the ENT surgeon for the paranasal sinusitis and vertigo, and monitors breast symptoms and repeats mammogram in 3 years. On 15th April 2024, Uganda Prison Service prepared a report stating that a follow-up examination of the applicant had been conducted on 12th April 2024 at Luzira Women's Prison. It was stated that the applicant did not receive trauma-focused cognitive behavioral therapy, neither was there any follow-up with an ENT surgeon to address the applicant's paranasal sinusitis and vertigo as recommended. Mulago National Referral Hospital. It was stated that on examination, she was found to be in fair general condition, and a mammogram indicated that the applicant had multiple fibrotic masses in the right upper quadrant of the left breast. April concluded by stating that assessment and monitoring of the multiple breast masses is beyond the capacity of the Uganda Prisons Health Services. I note that the report from Mulago National Referral Hospital, dated 8 February 2024, states that the masses are benign and recommend monitoring of the breast symptoms. It was recommended that the mammogram be repeated in 3 years. It is settled law that existence of exceptional circumstances is no longer mandatory for bail to be granted, as bail can be granted even where no exceptional circumstances exist. See the case of Uganda versus Colonel Dr. Chiza Besije, Constitutional Reference number 20 of 2005, where it was stated that proof of exceptional circumstances in an application for bail is not mandatory. However, when an applicant seeks to rely on exceptional circumstances, as in this case grave illness, the applicant is required to satisfy court that the grave illness is such that it cannot be managed while the applicant is in custody. See the case of Nyanzi Yusuf Siraj versus Uganda, criminal miscellaneous application number 134 of 2021. Section 16.3a of the trial indictment requires the medical officer of the prison where the applicant is detained to state that the health needs of the accused person are incapable of being addressed while the accused person is in custody. Section 74 of the Prisons Act, Cap 325, provides as follows: removal of sick prisoners to hospital. 74.1 says, in the case of illness of a prisoner confined in a prison where there is no suitable accommodation for that prisoner, the officer in charge, on the advice of the medical officer, may make an order for his or her removal to a hospital, and in cases of emergency, the removal may be ordered by the officer in charge without the advice of the medical officer. 74.2 goes on to say, a prisoner who has been removed to a hospital under this section shall be deemed to be under detention in the prison from which he or she was so removed. Where the medical officer in charge of a hospital considers that the health of a prisoner removed to hospital under this section no longer requires his or her detention there, He or she shall notify the officer in charge, who shall cause the prisoner to be brought to the prison if he or she is still liable to be confined in the prison. 4 says every reasonable precaution shall be taken by the medical officer in charge of a hospital and the other officers and employees of the hospital to prevent the escape of a prisoner who may at any time be under treatment in the hospital. The officers and employees of the hospital shall take such measures to prevent the escape of the prisoner as shall be necessary, but nothing shall be done under the authority of this section, which in the opinion of the medical officer in charge of the hospital is likely to be prejudicial to the health of the prisoner. Section 75 of the Prisons Act, Cap 325, goes on to provide for security measures. Prisons Act, Cap 325, denotes that where the prison facilities are inadequate, but the accused person's health needs can be addressed by procuring his or her attendance at external superior medical facilities, conveying the accused person to such superior facilities for medical attention as and when necessary, and returning her to the prison. Then the test of exceptional circumstances by reason of grave illness has not yet been met. I therefore find that the option to have the applicant access the medical attention that she requires outside the confines of the prison walls while in custody to ensure the implementation of the treatment plan recommended in the Mulago National Referral Hospital report of 8 February 2024, pursuant to Section 74 of the Prison Act, Cap 325, has not been explored. The breast masses having been found to be benign rather than malignant or cancerous, and the experts recommending that the masses be monitored and the mammogram be repeated every 3 years. Those masses do not qualify to be termed as grave illness, which cannot be managed while the applicant is in custody. In Sheikh Mohammed Yunus Kamoga versus Uganda, Court of Appeal Criminal Application number 77 of 2017, Honorable Mr. Justice Christopher Madrama stated that Section 75 of the Prisons Act 2006, now Section 74 of the Prisons Act Cap 325, allows prisons authorities to make a report that a prisoner is in need of outside medical treatment, inclusive of being admitted in hospital outside the prison walls. I accordingly find that the ground of existence of exceptional circumstances fails. I will now go to that decision. In this account has, among other things, proved that she has a fixed place overboard, has substantial sureties, is of advanced age, is the sole breadwinner of her family, is a first-time offender, and that there are no other charges pending against her. However, the charges against the applicant are grave. In all cases where an applicant or accused person is charged with a capital offense, the court must always have in its mind the overarching consideration of the gravity of the accusation leveled against the applicant. As stated in the case of John Muhanguzi Kashaka versus Uganda, Supreme Court Miscellaneous Application number 18 of 2023, being of advanced age, a first-time offender, and a sole breadwinner, all such factors which go to the applicant's credit recede to the background when weighed with the seriousness of the offense. In exercising its discretion on bail, court must consider all the circumstances of the case and consider whether it is in the interest of justice to grant the applicant bail. In the instant case, 10 prosecution witnesses have already testified. Disclosures have been made to the defense in respect of the other witnesses, and the hearing of the matter is set to resume on 10th March 2023 as a session with a view to expeditious conclusion of the case. In Yang Zeng Yun versus Uganda, Court of Appeal of Uganda Miscellaneous Application 99 of 2013, it was stated that the granting of bail by court to one before court is essentially an act of the exercise by court of its discretionary powers. The court considers all that is before it regarding the application for bail and reaches a decision based on the rules of reason, justice, and law. In the premises, the application for bail is disallowed on the following grounds. The prosecution case is advanced with 10 witnesses having testified and all the evidence has been disclosed to the defense. The hearing of criminal case 0100-2024 is set to resume on 10 March 2025 and will be heard as a session to expedite its conclusion. Signed and sealed copies will be available from the secretary.
Che si muove, tu sei di